You have the right to remain silent. Anything you say can and will be used against you in a court of law. You've heard those words your entire life. They're so familiar that most people stop thinking about what they actually mean. In fact, I think almost everyone misunderstands this warning. Most people hear it and think, well, that's for guilty people, or they're talking about confessions. Neither of those two things are true. In my opinion, this warning is one of the single greatest pieces of legal advice ever written. Not because talking proves you're guilty, but because every time you answer a question, you're creating evidence, evidence that you will never get back. One of the reasons this topic is so important is because talking to the police feels like the obvious thing to do. If you're innocent, your instinct is to explain yourself. You think the misunderstanding can be cleared up. You think that honest people have nothing to fear. You think that if you just tell your side of the story, everyone will realize that there's been a mistake. Those instincts are completely understandable. In fact, they're exactly what most people would do. The problem is that a criminal investigation isn't a conversation, it's an evidence gathering process. And once you understand that difference, the Miranda warning starts to make a whole lot more sense. But before we continue, I should say, this video is for educational purposes only. It's not legal advice. With that out of the way, let's talk about what this warning actually means. One of the biggest misconceptions about police questioning is that people think they're having a conversation. They're not. They're creating evidence. Every answer becomes another piece of information that investigators can compare against surveillance footage, cell phone records, other witnesses, physical evidence, or statements made months later. I like to think of it like putting together a 1,000-piece puzzle. Investigators don't begin with the completed picture. They begin with scattered pieces. Every answer you give helps them decide where the next piece belongs. Maybe your answer confirms something that they already suspected. Maybe it contradicts another witness. Maybe it sends them looking for evidence they otherwise never would have looked for. Your statement isn't just another piece of evidence. Sometimes it's the roadmap for the rest of the investigation. And once those words leave your mouth, they don't belong to you anymore. Over the years, I've seen this play out more times than I care to count. I've never seen someone talk themselves out of an arrest after the police had already developed probable cause. I have, however, seen people talk themselves into an arrest by giving officers the missing pieces that they needed to establish probable cause. Now, I'm not saying that every conversation with the police ends that way. Of course, it doesn't. What I am saying is this. When you're standing on the side of the road or sitting in an interview room, you usually don't know whether you're helping yourself or helping the investigation. And that's exactly why experienced criminal defense attorneys are so cautious about clients giving statements before we've had a chance to evaluate the evidence. Here's the first problem. Human memory is imperfect. Even honest people get things wrong. You might remember getting somewhere at 3 o'clock, and it was actually 2:30. You think someone was wearing a blue shirt, when in fact it was black. You think you left through the front door. Security footage shows you left through the side. Does that mean you lied? No, it means you're a human being. Unfortunately, prosecutors don't simply compare your statement to your intentions. They compare it to the evidence. The jury hears, he said one thing then and another thing later. The problem isn't that you talked. The problem is that you talked before you knew the whole story. People sometimes ask me, why would an officer ask me a question if they already know the answer? Well, because your answer has value even if they already know the truth. If your answer matches the evidence, they've learned something. If your answer doesn't match the evidence, they've learned something. Either way, your answer gives them more information than they had before they asked the question. Imagine this. An officer asks, were you at this house yesterday? You immediately answer, no. Now that seems harmless, except maybe they already have ring camera footage. Maybe your car drove by. Maybe your phone connected to a nearby cell tower. Maybe you stopped there for 30 seconds to drop something off and completely forgot about it. Now, you haven't just answered a question. You've unintentionally damaged your credibility, and you didn't even know the evidence existed. This is the point almost nobody thinks about. When you answer questions, you're committing yourself to a legal strategy before you even know what the legal issues are. In over a decade as a public defender and now in private practice, I've watched this happen over and over. People think that they're helping. And I understand why. Most people have been taught from childhood that if you've done nothing wrong, you should simply tell the truth. The truthful thing to say before you've seen the evidence may not be the complete picture. And once you've committed yourself to one version of events, it can become much more difficult to explain why your understanding changed after all of the evidence came to light. So instead of helping themselves, they're making their lawyer's job dramatically harder. Suppose you tell the police, I wasn't there. Months later, your attorney receives the discovery, and there was a surveillance video. You actually were there. But here's the important part. The evidence also shows someone attacked you first. You acted in lawful self-defense. You absolutely have the legal right to raise self-defense. But now imagine the prosecutor standing in front of the jury. Ladies and gentlemen of the jury, don't believe this self-defense story. When the defendants first spoke to the police, he didn't say he defended himself. He said he wasn't there. Do you see the problem? The problem wasn't self-defense. The problem wasn't the evidence. The problem was talking before you knew what the evidence was. Here's another example. Suppose an officer asks how much you've had to drink. You honestly answered, just 2 beers. Months later, surveillance footage shows you actually had 4. Maybe you simply forgot. Maybe the drinks were spread out over several hours. Maybe you weren't trying to deceive anyone, but now the prosecutor isn't arguing that your memory wasn't perfect. They're arguing that you lied. Again, the problem isn't necessarily what happened. The problem is that you made a permanent statement during one of the most stressful moments of your life before you had seen the evidence. There's another danger. Sometimes investigators don't know something until you tell them. Maybe they don't know why you were there, and now they do. Maybe they don't know who drove the car, and now they do. Maybe they don't know where everyone went afterward, and now they do. People think, I'm clearing this up. Sometimes. But sometimes they're filling holes the investigation hadn't filled yet. People sometimes ask me, if I'm innocent, why would a lawyer ever tell me not to talk? Here's why. Because I don't know the evidence yet, and neither do you. I don't know what witnesses will say. I don't know what surveillance video exists. I don't know what forensic evidence exists. I don't know what another suspect may have already said. I don't know what the police got wrong, and I don't know what defenses the evidence may support. My job is not to create a story. My job is to understand the evidence. Only then can I determine what legal defenses actually fit the facts. Sometimes what looks like an alibi case turns out to be a self-defense case. Sometimes what appears to be an assault case turns out to be an identification case. Sometimes the strongest defense has nothing to do with what my client originally thought was important. That's one of the reasons that experienced defense attorneys are so reluctant to have clients give detailed statements before we've seen the discovery. My job is to determine the strongest truthful defense after I've seen the entire picture. Every unnecessary statement makes that job harder. Now go back to the Miranda warning. Listen to it again. Anything you say can and will be used against you. Notice what it doesn't say. It doesn't say anything you say can and will help you. The warning isn't saying that because the law is unfair. It's saying it because history has repeatedly shown that speaking to investigators without understanding the evidence is extraordinarily risky. The Fifth Amendment exists to protect innocent people just as much as guilty people, because innocent people panic. They guess, they misremember, they speculate, and they commit themselves to facts before they know which facts actually matter. There's one more thing I'd like you to think about. Human memory changes. That's normal. As time passes, we remember additional details. We correct mistakes. We realize we were wrong about certain things. That's how memory works. But your recorded statement never changes. Months later, a jury may compare your testimony to something you said during one of the most stressful days of your life. Your memory evolved. The recording didn't. So what should you do? It's actually very simple. Be polite, be respectful, do not argue, do not resist. If you're being questioned about possible criminal conduct, say this: Officer, I am not going to answer any questions without my attorney present. And then stop talking. Not because you're guilty, because you understand how evidence works. Every word you say creates evidence. And once it exists, you no longer control how it will be interpreted, how it will be investigated, or how it will be presented to a jury. The next time you hear someone say, anything you say can and will be used against you, I hope you hear something different. I hope you hear this: be careful, you don't know the whole story yet. I'm Joel Chorny. Your rights matter. Protect them. Stay safe, and I'll see you in the next video.